Good afternoon, everybody. My name is William Smith. I'm a senior district court judge on the federal court here in the District of Rhode Island, and also a senior fellow here at Watson this year, which has been great fun. And as part of that study group that I'm teaching, I invited my friend and colleague, Chief Judge Jeff Sutton, to come speak. And wisely, Dean Friedman thought it would be nice to do a fireside chat with Judge Sutton for a broader audience. So I want to just spend a minute to introduce both of them. I don't think people here need much introduction to Dean Friedman. You know a lot about him, and he's asked me to spend my brief comments on introducing Jeff Sutton. So I'll honor that request. But Chief Judge Sutton has been on the Sixth Circuit Court of Appeals since 2003, so 23 years. Before that, he was the state solicitor for the state of Ohio and a partner at Jones Day, which is a major law firm founded, I believe, in Ohio. In Columbus, he has argued 12 cases before the United States Supreme Court and many, many cases before state Supreme Courts and federal courts of appeal. He was a law clerk on the Second Circuit Court of Appeal to Thomas Meskill, and clerked on the Supreme Court both for Lewis Powell and for Antonin Scalia. And he has taught at the University of Ohio College of Law, where he received his law degree now for since 1993 as an adjunct professor. And there are two things of note that I want to mention about Judge Sutton. One is that he is probably the country's leading scholar on the issue of state constitution, state constitutional law, and state law. He's really the evangelist, if you will, behind the kind of the resurrection of state law, and something that has been sorely neglected over many decades. And I know he's going to speak about that. He has written two terrific books on this topic. One called 51 Imperfect Solutions. States in the making of American constitutional law. Second, more recent book is Who Decides? States as the Laboratories of Constitutional Experimentation. He's working on a third book now. He's also the author and co-author of a case book on state constitutional law and the law of judicial precedent. The second thing I want to mention to you is that within the federal judiciary, he's a very big deal. So this is, kind of behind the scenes and in the weeds. But Chief Judge Sutton is not just the chief judge of an important circuit court of appeals, but he's been picked by the Chief Justice of the United States to chair what's called the Executive Committee of the Judicial Conference. The Judicial Conference is the policymaking body of the federal courts. It's chaired by the Chief Justice, and the most important body within the Judicial Conference is the Executive Committee, and he chairs that. And none of this you would hear from him because he's an incredibly humble and self-effacing person, so he'd never tell you all these things about himself. But I think you're in for a real treat in hearing from him today. So with that, I'll go sit down.
Thank you very much. Thank you, Judge Smith. I really appreciate not only your introduction today, but your role here as a senior fellow this year. It's been really a treat for our students to get to interact with you and all the great visitors you bring. I want to welcome everyone here to the Watson School for another event in our launch series. And We're really, again, thrilled to have Judge Jeff Sutton here to talk through so many different interesting issues of the way that the courts operate and how policy interacts with that have evolved and are so important in the current environment. This is one event in a broader series of events that we're doing this year to mark the inaugural year of the Watson School. And we have an ongoing challenge to students in the room. The students who attend the most launch events will receive a prize. And so there's a QR code, I believe, in the back to scan on your way out. So please do that.
Do they not really want to be here?
We're using all of our tools at the disposal here. I would also, we have an exciting series. This is our last event here in the fall, but we have an exciting series of events in the spring. One that I will particularly mention that's going to be in some ways related to the topics we talk about here today. We have Brown alum and current U.S. Attorney for the Southern District of New York, Jay Clayton, who's coming in April. So that'll be another kind of legally oriented event. Now, the purpose of these talks are to foster conversation around some of the world's most important policy issues with people who are really at the forefront of those issues in the world. And, first I want to just thank the judge for coming here and contributing their incredible experience and perspective to our exchange of ideas, right? This is just critical to our mission of promoting a just, peaceful, and prosperous world through research and teaching. Now, over the course of this event or others, you hear opinions in all sorts of ways. You may hear opinions that you disagree with. You may hear opinions that you really, really disagree with. And that's a good thing, right? We're trying to expose people to a really broad set of perspectives. And I think that's part of what makes exchange at a school like this so rich. We best understand disagreement by being respectful, curious, and gracious, respectful of each other's differences, curious to understand more about what underlies divergent perspectives, and gracious in interpreting the intent of others' comments. And so, you may not just disagree, you may feel the need to protest, that's okay, but doing so can't interfere with other people's right to engage in the debate, and even for a brief time. And so I'm confident in our community that we have capacity to kind of have all these conversations and learn from them. And so let's get to our speaker. And so, Judge, I always like to start these just by getting a little bit of a sense for the audience of kind of the trajectory that people followed to land where they are. And so Judge Smith gave us a little bit of your background, but I just, for those in the room, I'm really interested in what was your trajectory towards becoming a lawyer once you were on the bar, the trajectory towards becoming a judge, and eventually to the role in which you now serve.
Great. Well, first of all, let me just say thank you for inviting me, Dean Friedman. Thank you, Judge Smith, for that very kind introduction. And I'm just thrilled and honored to be here. I went to Williams College, which is a great school, but had the Watson School existed back then, and had I been able to get in, maybe that would have been an issue. I would have come here because it just seems like a great program. So my background, law was a third choice. No lawyers in my family. They were all educators, missionaries, and I actually don't think my family was that proud, actually, that I went to law school. I think they thought I was selling out. So it took me a while, 4 years between college and law school, but I ended up loving the law. And I can't tell you how much I enjoy it and how terrific a career it's been. I had 2 years clerking. As Judge Smith pointed out, I did kind of a conventional thing, going to a big law firm, which I enjoyed, I must say. But the big break for me in my career was working for government. For about 3.5 years, I was the State Solicitor General of Ohio and just got to do an amazing number of cases, got to argue in the U.S. Supreme Court before I otherwise would have. So, working for government is just a terrific way to get engaged, get responsibility, learn. So much of all my, quote, scholarship grows out of that 3.5 years working as State Solicitor General of Ohio. So that was really a big break for me. And I went back and practiced for a while, and then had the good fortune of becoming a judge in 2003. And been doing it for a while.
And again, for we're not at a law school here, so just for the background of people in the room, tell us what the job is on the Sixth Circuit of Appeals as both as that per se and as the chief judge, and then we can kind of talk about what it doesn't do as a way to transition into the issues that Judge Smith discussed around federal and state courts and law.
Well, good for you for suggesting I do this. I'll do only a little of it. I thought yesterday I'd have to spoon feed all this stuff to the students because they're not law students, and their questions were better than most of the questions I get from law students, to say nothing of lawyers. So I'm pretty confident this group has the whole thing down. And quite sadly, unless you've been hiding under a rock, you've been following that the courts have a very big role in society right now. So I'm pretty confident people understand appellate courts. But the one thing about the federal courts of appeals is there are 12 of them. You can call them regional courts. For example, mine covers Michigan, Ohio, Kentucky, Tennessee. It's a really interesting mix. Two, below the Mason-Dixon line states, two above. We go from the Mississippi Delta up to the Canadian border, Lake Superior. So huge diversity of people, problems, issues, city, rural, you name it. And there's 11 other regional courts, and we're kind of the interim between the trial courts and the U.S. Supreme Court. The big difference between our job and the U.S. Supreme Court's is most of their cases, they have discretion whether to take the cases. They decide about 60 a year, and I, on the other hand, would write 60 opinions a year. So I don't really we have to take the cases, we have to decide the cases, and we usually sit in groups of 3 to hear them, not groups of 9 as at the U.S. Supreme Court, although every now and then the full court will hear a case if it's a really big issue, and that means all 16 of us will decide it. So that's like a unruly faculty meeting, I think would be my analogy. But it's
you clearly have never been to a faculty meeting.
Well, you tell me. You tell me this. I think judges are a great group. I love their company. But I have found the more of them in the room, the harder it is to reach consensus.
Well, that is a universal, the more people in the room, the less progress you make.
So Judge Smith has an awesome job. He is a judge of one. So
let me ask another question, but just let me add, we have a bunch of seats down here in the front. Judge Smith, Sutton and I will not bite. So please, if you're standing in the back and you would like to sit, we have some seats over there. We have 4 seats along the front. We have 1 seat over here next to Ari. So please feel free to come on in. Now, you are at the Sixth Circuit of Appeals in the federal court system, and a lot of your work is focused on what does not happen in the federal court system. And this is a way in which I think the U.S. system is set up very differently from the way many systems are set up abroad. And so, again, one more question, and just in terms of primer, can you say a little bit about how we in this country divide things up between the states and the federal courts, and kind of what's a bit of the logic? Why has it come to be that way?
Yeah, I mean, this is really important, and this is an area where our civics education is, in my view, quite unfortunate because it's basically zero. When we learn, if you think of your first civics class, maybe in middle school and then high school government, to the extent we're going to talk about the judicial branch, it's invariably going to be the federal courts, and it's probably going to be focused on the U.S. Supreme Court and the U.S. Constitution. That's all well and good. It's very important. It's a national constitution, national court. They're responsible for some very big things, as this epic term at the court shows. But the reality in America, if you care about the rule of law, is that most people will experience the courts and law in this country through a state court. 96% of cases in this country go through the state courts. To be more specific about it, in the federal courts in a given year, 400,000 cases roughly will be filed in the federal courts. The counterpart number, you can do this in a lot of different ways, but at the state level, it's roughly 50 million. All right, 400,000, 50 million. and our only education is about the federal side of things. And I've always thought that was quite unfortunate, because trust in courts, credibility of courts, belief in the rule of law, if you don't get that in state court, for most Americans, that means they're not going to think highly of courts. The average American doesn't sit there and go, well, that was a state court experience, that was a state judge, as opposed to a federal judge. They're just thinking courts. And so, to me, one reason I really care about state courts and state constitutions is because that really is where most of the action is. And the typical American that has the misfortune or intentionally goes to court, it's going to be in state court. That's usually what's going to happen. So it's very important for us to understand how those work. But the key thing is we've got two sets of courts, and the only slight complication, just to add, is it is true that there is one high court that sits above everything. Chief Justice Roberts his title is actually Chief Justice of the United States. It's not Chief Justice of the United States Supreme Court. It's not Chief Justice of the federal courts. It's Chief Justice of the United States. And that's important because if a federal claim, an issue of federal law, an issue under the federal Constitution goes through state court, the losing party has a right to go to the U.S. Supreme Court. So that's a very important feature of our system. The 50 high court justices are the final say about state law, state constitutions, but they do not have the final say about the meaning of the federal Constitution, which is quite important in terms of making sure we have a unified set of interpretations about, say, the meaning of free speech or equal protection.
And so if it were just super clear that there's some state issues and there's some federal issues, then maybe the division that you're talking about would not be so consequential. But right, we've had not just over the history of the United States, but even today in a very dynamic way, there are kind of contentions about what belongs in state courts, what belongs in federal courts. Many issues that came up during the pandemic. The issue of abortion is one that's been recently switched from a federal court issue to a state court issue. You, as Judge Smith said, you've kind of done an enormous amount of work on this. What are you seeing as the key issues in this question of kind of what belongs in one set of courts, what belongs in another, and what are the consequences of that choice?
Yeah. But let me start with one thing and then make sure you follow up so I'm getting to all the things you want me to chat about. But let me start with one thing that if you try this at a cocktail party, you won't be invited back and you will see some eyes glaze over. But let me give you a way to deal with this problem. The word federalism is, if you had to pick one thing about the American government that's very significant and makes us quite different from most governments in the world, it would be the word federalism. And we all have a terrible problem figuring out how to define it, what it means. And it just kind of is one of these weird words. And then when you add to it that we had federalists and anti-federalists, we're just like, God, I don't, the summa cum laude graduate from Brown this year still couldn't do anything with this. And so what I want to try to do is help you think about this in a way that maybe will make it a little easier to appreciate what I think is just so critical about American government. And the key thing about federalism is to remember it's a question. It's not an answer. So the question of federalism is the great question in American history. I mean, this, by the way, you'll get an A in every history or poli-sci exam you ever write if you pay attention to what I'm about to say. The great question in American history is what should be resolved nationally and what should be resolved locally, right? Federalism's a question. It's not an answer. There's not a single year in American history from late 1775 all the way to the present where we are not intensely debating whether this policy issue should be resolved locally at a city level, statewide at the state level, Rhode Island level, or nationally, U.S. Supreme Court, Congress, the president. And again, question, not answer. You mentioned COVID is a really wonderful way to appreciate that even if we can't define federalism, in our American bones, we know what it means. And it's actually one of the few things we actually agree about. And that's hard to say about American government right now. Let's look backward on COVID. It's doesn't make you feel good to think about that. But politically, it's a really great way to illustrate this, because I'm pretty confident you're going to agree with me about how the federalism question was answered back in COVID. So one part of COVID led to some questions that just had to be answered by the national government. And that was a vaccine, all right? If you're going to produce a vaccine, Ohio and Rhode Island, I mean, these are two great states, but I just don't think we were going to be better than the federal government at bringing to market a vaccine as quickly as they did. I mean, it was quite historic what they were able to do. That was a job for the national government as a matter of resources. It was a job for the national government in terms of knowledge and expertise, because the federal agencies way bigger than the Rhode Island or Ohio counterparts. I don't think anyone, I mean, people debate vaccines, but I don't think anyone debates the point that if you were going to bring a vaccine to market quickly, that was a job for the national government. Now let's flip to some things that I think in retrospect we would all agree were properly handled locally. School shutdowns, mask requirements, vaccine requirements. Those were such complicated issues. Can you imagine if we'd given one person responsibility as to what to do in every school in the country, whether a rural school, urban school, suburban school, God only knows? And this is, Brandeis's amazing insight that when you have a difficult policy problem, you should consider it a blessing that there were 50 different state laboratories of experimentation, not a metaphor in COVID, literally laboratories figuring out who lives and who dies with mask requirements, opening schools, shutting down schools. We figured this out. And, I don't want to pick on this one governor. I mean, there but for the grace of God go all of us, for not having positions of responsibility during COVID. But if you remember March of 2020, I mean, the nightly news was horrifying. They were talking about emergency rooms running out of beds. What do we do with all these people with serious COVID symptoms? And in New York, I mean, I could just see myself doing the exact thing they did. You're realizing a lot of the people coming in were elderly. They realized skilled nursing homes had empty beds. Why not move the people from the emergency room to the skilled nursing home? And of course, we learned eventually that the population most vulnerable to COVID was the elderly. Thank God that was an experiment done in one state for 2 weeks. Yes, sadly, some people died, but a lot fewer people died than would have died if we had done that experiment on the whole country at once. So, COVID is, as sad as that experience was, it does illustrate that we actually all believe in federalism. We do appreciate that some jobs are for the national government and some jobs are for the local governments. Now, in a lot of areas, it's actually, we don't agree. It's really complicated. So you mentioned abortion. That one splits us right down the middle in this country. Probably half of Americans think this is a job that we should nationalize on one side of the issue. I mean, that's the problem. Both sides of this issue would be happy to see it nationalized just in their favor. But you probably, I probably would say there's a high percentage of Americans that think that it is fine to do this locally, state by state. But I know for a fact there's at least 50% of Americans that think that's unfair, unfortunate, and that, they should have either preserved Roe or found some other way to nationalize it. So the fact that we can agree on some questions that should be national and local obviously doesn't mean we agree on all. And, abortion's a great example of one we very much don't agree on. But it's quite remarkable what has happened since Dobbs. If there's a case that has taught Americans about the power of state courts and state constitutions, it is Dobbs. Because I think I can just imagine this kind of conversation at the dinner table. So June of 22, I think Dobbs comes out. So if you didn't have lawyers in the family, you're coming home and you're going, I just read the headlines. I think the U.S. Supreme Court just outlawed abortion, best I can tell. And then a month or two later, the Kansas Supreme Court issued a decision under its constitution saying in Kansas, you have a right to abortion that actually went way beyond Roe. And people saying, wait, how could Kansas allow abortion in Kansas and the U.S. Supreme Court, which speaks for the whole country, say it's outlawed? Well, of course, what the U.S. Supreme Court was doing was not saying abortion was outlawed across the country. They were saying the federal Constitution didn't speak to it. I realize that's a super controversial decision, but what I think is remarkable about the after effects of it is it did teach our 330 million Americans that you have two shots, not one, to protect rights in this country. And one of the reasons I've spent so much time outside of my day job on state constitutions is I just feel like it's a terrible injustice to all of us not to appreciate that when you lose a case at the U.S. Supreme Court, when the right you really care deeply about is not recognized, that is not the end of the story. That is not the end of the game in a federalism country. Every state or local law in this country, every single one, has two protections, not one. The federal Constitution potentially gives you a right, and the counterpart state constitution potentially gives you a right. The irony that Americans didn't understand this is that all of our federal rights come from state constitutions. I mean, no less than Gordon Wood. That's a name that people ought to recognize here. The greatest era of Constitution writing, in his words, was late 1775 to 1786, which happens to be a full year before the Summer of Philadelphia. And by the time they get to Philadelphia, all they're doing is cutting and pasting from the state constitutions that had already been written, except in Rhode Island. You guys liked your charter. I think Rhode Island, I think you liked the cross out. I think it would have been so much fun to be in that room. Just so everyone gets this, whatever that, some of you know the year, but let's just say it was 1642, the Royal Charter. It's the 1600s at some point. So it's the Royal Charter, and it sets the rules, structure of government. And my understanding of the way Rhode Island did this is they weren't eager to write their own constitution because they fundamentally thought a parliamentary system worked. They just wanted the legislature to be a Rhode Island legislature, not an English legislature. So I think it was literally taking a pen. I love the
a quill.
A quill. That's what I love. Is quill. You've got your inkwell, and you're like, okay, every time it mentions king, out. Every time it says parliament, we put legislature. And so that's what you guys did until your great door rebellion. But anyway, I don't want to, I'm a visitor. I'll let you educate me about Rhode Island history, but there's a lot of great Rhode Island history. You should be very proud of it.
So I think that was, it's incredibly helpful in terms of laying out the kind of the broad outlines of this debate. I think, you talked about a lot how this decision kind of can go back and forth between what gets decided in federal courts and in state courts. One dimension of that is what's being recognized as a right. We can talk about that. But I think another complication that comes up in both of the cases that you mentioned is that the 51 states, or including
governments,
it's 51 kind of constituent governments. These are not hermetically sealed containers, but what happens in one state can affect that in another, and that can either be like in COVID, where obviously, COVID was a communicable disease in a way that, living on, one side of a border that had one, say, very restrictive set of policies, when you're right across the border from a state that had very open policies, like that, is a, very different experience. The issues around abortion since Dobbs are another example where, you have states like Texas that are kind of actively trying to outlaw in various ways their own citizens from going to other states or participating in any way in things that are, by the logic of federalism, legal in Massachusetts. They are illegal in Texas. How do you think about resolving? How has in practice different state courts and the federal courts as kind of overseer at the end of the day, in some ways of it all, resolve some of these issues or dealt with these issues when what's going on across states interacts with each other in ways that bring conflicting solutions to the same problem against each other? Yeah.
Well, so in Justice Kennedy's words, federalism is where the framers split the atom of sovereignty. And if you just think about that phrase, and if we have scientists here, that's either can't be done or generates a hell of a lot of chaos. And it's actually a great thing to remember. The federalism is not easy. It's actually really complicated to think of two sovereigns in one place. A lot of the framers thought federalism was impossible. You're either the government or you're not the government. You can't share sovereignty was the concern. And so that kind of tension manifests itself from 1776 to the present, and that's why it is always a question, not an answer. I would add, those examples you're giving, is the question's actually gotten harder to answer over time because, a Rhode Islander in, 1780, the odds were high you were never going to get to Ohio. You weren't jumping on planes, buses, trains. And so we were much less interconnected. And now we're incredibly interconnected. And that creates huge complications. I mean, just think of regulation of business. What are the rules? What are the rights of being an American? And now I will say there's a plus about the modern world. It is a lot easier to leave another state for the nirvana of Ohio. That wasn't something everyone could experience. But, we got Californians coming in right and left. They're tired of the sun. They want some a gray November, and we bring it to them every day.
A colleague of mine just yesterday told me how excited he was to be spending the winter holidays in Toledo. So,
well, that's my wife's from Toledo. No Toledo jokes. That was a Toledo joke, and I am going to defend her honor. 40 years in, we have a great marriage. I love Toledo. I was married in Toledo.
Toledo will be the home of the National Numismatic Museum starting next year. I learned from my colleagues. So I'm not mocking you. That is I'm totally serious. It will be the home of the National Numismatic Museum.
Dean, so I'm going to start calling you John.
You can call me whatever you like. If you are a fan of rare coins, then Toledo is your space.
That really cracks me up. There was a huge Ohio coin scandal. It was headquartered in Toledo, so I don't even know why they're doing this. But anyway, back to my point. So let's just talk about another way of thinking about your really good question of whether you want to think of it as COVID policy, abortion policy. We had this with marriage policies before the Obergefell decision. How do you do this? And, and I think I suspect everyone in this room has the intuition. I think most Americans have the intuition that if we're talking about constitutional rights, that phrase, that big phrase, it's very strange to imagine people in Providence having different rights than people in Toledo. That just doesn't make much sense. So the answer to that problem, in my view, and I agree, I'm dignifying your point, is that when the federal Constitution speaks to the issue, yes, federalism's not a question. The question has been answered with the passage of the First Amendment, the U.S. Constitution, and the meaning of free speech has to be a meaning that applies everywhere. And I think that's actually not too difficult. I think what gets complicated, and the reason we still have all these court cases, are two types of problems. One, we're not sure what really constitutes free speech protected by the First Amendment. Like, it's just not easy. It's a complicated issue. I'll give you an example. The federal courts have struggled for a long time about whether commercial speech, telling someone to buy Colgate toothpaste, should that be treated like political speech? We've really struggled with that. So there's an area where we know the First Amendment should apply everywhere. We just don't know what it means. And if you're not sure what it means, it's a little complicated whether that should apply everywhere, because you might make a mistake, like the governor during COVID. What's even more complicated, and I think this is what made abortion such a complicated thing for the court and a complicated thing for the country. There's not a right to privacy clause in the federal Constitution. There's not an abortion clause. There's a due process clause there's an equal protection clause. And I think the thing that has just been very difficult for well-meaning justices on the U.S. Supreme Court is just trying to figure out, what does due process mean with something like the right to privacy? They've just found it very complicated. And one way where Brandeis potentially gives us help is, there's no reason, let me just step back for a second. When Brandeis was talking about experimentation, he was talking about legislatures. So what he was saying is, hey, you got this new policy problem, data privacy, opioids. Let different state legislatures experiment. If someone comes up with a winning insight, then by all means nationalize the answer through Congress. So he was talking about labs of experimentation, legislatures. One of the things that's very exciting to me about America circa 2025 is we can use state courts to do the same thing. So in an area where the U.S. Constitution doesn't directly speak to it, and it's just hard to figure out what the right answer is, one way to give an assist there is have the state courts in the vanguard, have them doing the initial experimentation the way state legislatures do, and when a winning insight emerges, by all means nationalize it. But if a winning insight doesn't emerge, not the end of the world to have 3 or 4 different approaches across the country, given that you're dealing with, an imperfect, answer. It's not clearly the right insight.
Let me push you on that, because if we're, let's take marriage equality as an example, right? So Massachusetts is the first state to legalize single-sex marriage through a decision of the Superior Court or Supreme Court of Massachusetts. So again, if we now have 51 areas where there's just kind of independent policies, you could say, okay, fine, some areas are going to allow this, some areas are not. But then states are obligated to recognize each other's, if you get married in Massachusetts and then you move to Texas, we do not want a system where everybody has to get remarried in Texas. And so states have to recognize each other's marriages. But now this opens up, anyone who wants can move to Massachusetts temporarily, get married, and then move back to wherever else they are. And that now seems to kind of undermine the logic of letting each state choose. And, that's an example coming from something that's kind of more of a kind of progressive side, right? I think what's happened since Dobbs in some of these states since Dobbs, it kind of cuts the other way, where people are saying, we're actively trying to prevent people from taking advantage of the fact that Massachusetts has a different answer about in what circumstances abortion is legal than Texas. And if there were just people in Massachusetts and people in Texas and kind of, ne'er the twain shall meet, then, one could think about that world. But because people can move back and forth between, it's kind of the sovereignty isn't just shared between the federal government and the states. It's almost shared between the states when you have these kind of interactions. So how in practice can this work out to really let the laboratory idea work? Yeah.
Well, you tell me how you feel about this, and I'd love responses from the audience eventually on this as well, because this is my next book project, and I'm really excited about it. So now's the time to talk me off the ledge. So the idea is that when you think about con law in America, and particularly about rights, that there are really 3 stories in American con law. And notice I'm saying American con law, not federal, American, state and federal. And here are the 3 stories. And I'm directly answering the question, but I just want to set up the answer. Story number 1 is our greatest con law story, and that would be Brown versus Board of Education. If we look back on that experience, I think we can all appreciate that not only was Brown correctly decided by the U.S. Supreme Court, but that the problem was the U.S. Supreme Court's decision in Plessy, and that Jim Crow could have been avoided had the U.S. Supreme Court correctly nationalized an end to segregation by race. There's an equal protection clause. It was a fair construction of it to say it prohibited segregation. And that's a pretty good example of a world in which, by waiting until getting Plessy wrong, waiting until 1954, you had a lot of states in this country doing anything but delivering on the promises of the Declaration, to say nothing of the promises of the 13th, 14th, and 15th Amendments, particularly the 14th Amendment. So that's a nationalization story. That the mistake was not nationalizing from the get-go. We paid for it. We're still paying for it. And really, really unfortunate. The second story is the Brandeis story, and the marriage story is a great illustration of the marriage of the Brandeis point. So the marriage story, everyone thinks starts in 2003 in Goodrich. It does. It's a very, very important decision. But the story really starts in 1971, I think it is, or 72. I think it's 72. U.S. Supreme Court has an opportunity to address whether the 14th Amendment protects marriage equality. They get a decision from the Minnesota Supreme Court, which says no, but they're construing the 14th Amendment. That's why the U.S. Supreme Court back then had mandatory jurisdiction over it. Not a single justice in 1972 was willing to say the 14th Amendment protected marriage equality. The losers of that case have two options: embrace misery or seek recourse in the states. And that's what happened. In fact, an interesting part of the story is marriage was pretty far down the list of priorities for the gay rights movement because they had bigger fish to fry, not losing jobs, sexual intimacy, inheritance, visitation. I mean, there were a lot of things that were really the focus in the 70s, 80s, and 90s until marriage became a priority. Believe it or not, before Goodrich, the Vermont Supreme Court had a case in 1998. It's sometimes called the marriage light case because what the Vermont Supreme Court did is used its common benefits clause to say that a married gay couple would get the same benefits of marriage that a heterosexual married couple would get, but they wouldn't get the title marriage. So that's why it's called marriage light. And then that leads eventually to the Massachusetts decision, which, if you care about this issue, is the heroic decision. I mean, that was the bold decision in 2003. It was not bold in 2015 to be doing this. It was bold in 2003 to be doing this. That led to other states. Sometimes it was one step forward, two steps back. In fact, Hawaii had that exact experience before the Vermont decision. The Hawaii Supreme Court recognized gay marriage under its constitution, not the U.S. Constitution, but then the people of Hawaii amended their constitution to get rid of that ruling. That's why it was one step forward, two steps back. But after the Massachusetts ruling, things stuck. Other state courts did this. Other state legislatures did this. People forget that the U.S. Supreme Court in 2013 had an opportunity to nationalize marriage equality in Windsor. And what they decided to do was lead by example. What they did was they nationalized marriage equality under all federal statutes. You couldn't discriminate based on being gay with a federal statute when it comes to marriage. Left the state laws alone, let 2 more years of state activity occur. And by 2015 in Obergefell, everyone knew which way the wind was blowing. I was probably 2/3 of the states either had permitted a marriage equality specifically or had chosen not to appeal decisions requiring marriage equality. So that, to me, that's the second story, and I'll call that the dialogue story. And when Justice Kennedy writes Obergefell, this is just what he says. He says the meaning of marriage in America has been changing for decades. That change has occurred at the state level primarily and has led to a dialogue with us, the U.S. Supreme Court, which is what ultimately led them to nationalize it. Now, one thing that separates the marriage story from Brown is, the 13th and 14th Amendments are about race discrimination, all right? There's no getting around that. You would not call them about marriage equality in, say, the 14th Amendment in 1868. No one thought that was the point of what they were doing in 1868. So that's why that's an issue where the Brandeis model helps, because let's face it, things changed in this country about how we thought about sexual intimacy, marriage, who can marry whom. And when you have change in society, there's a lot to be said for allowing some experimentation before you nationalize. So that's why I call that the second story, the Brown story. The third story, and this is the most provocative, but I'll give you an example of it, is that if you really care about something, you really care about a right, don't lose sight of the possibility that you might protect it most effectively at the local level, whether it's the state level or the city level. Another way of putting that exact point is be careful of getting what you want when you try to nationalize. sometimes it will actually undo the very thing you care about. And let me illustrate that with the death penalty. And I'll just say one point as a caveat. Judges don't usually talk about their political preferences, but to illustrate this one, I just want to point out that as a citizen, I would get rid of the death penalty if I could. As a judge, however, I have to follow the written constitution, precedents, etc. So it's difficulty of being a judge. You sometimes have to do things you'd rather not do, upholding a death penalty, conviction. If you look at statistics in this country about executions, they probably, I don't know this early part of the story, but I'm pretty confident it would be roughly the founding to the 1930s, upward. 1930s, it peaks at roughly 300 a year. Can you believe that? And in the 1930s, we're executing 300 people a year in this country. From the 1930s to the late 60s, early 70s, it's a straight graph line, just goes straight down, ends at zero for several years. Remember, the 60s are a time we're reassessing a lot of things. That included the death penalty, how it was implemented. No state, federal government, no one is executing anyone in the late 60s, early 70s. At the same time, quite a few democracies that share our values in Europe, Australia, get rid of the death penalty through their legislatures. U.S. Supreme Court in a case called Friedman in 1972 says, well, what could go wrong if we just get rid of it? No one's using it. Lots of other democracies that share our values have gotten rid of it. Let's just call it quits. So they issue this fragmented decision, but clearly a majority, that says no one can be executed in this country under existing laws. I think this is an American trait. I don't know whether it's a good trait or a bad trait, but I just don't think Americans like being told what to do. They did not like being told they couldn't execute people even though they weren't executing people. Anyway, it led to this terrible backlash from my perspective. One state after another said, we'll show you, passed new laws. In a decision in 1976, the U.S. Supreme Court had to back off. Guess what happens to the number of people executed in this country? Remember, it had gone from 300 a year down to zero for several years. It goes straight up to roughly 100 a year by the year 2000. People were executed in this country because the U.S. Supreme Court nationalized abolition to the death penalty. I'm very confident people would have not have been executed if the U.S. Supreme Court had said, hey, let's let this continue to play out the way it's playing out. We do not need to enter the conversation. Well, whether I'm right about that or not, guess what's happened since 2000? U.S. Supreme Court has largely stayed out of it, and it's gone down not to zero, 25 a year. And you know what the decision has been made by people that want to abolish the death penalty the way I do? This is going to be a state-by-state fight. You're going to go to one state and convince the governor not to schedule executions. You're going to go to another state, ask their state Supreme Court, like your neighbor Connecticut, Washington, to prohibit the death penalty under their state constitution. You're going to get constitutional amendments, or you're going to get legislation ending it or leaving it for just the most exceptional cases. So, who knows if I'm right about this, but I do think it is true in American history that there are rights and interests that have been most effectively protected at the local level. And that there are times when nationalizing actually dilutes the right you care about, if not leads to a backlash, which was, of course, the unfortunate part of the death penalty story.
So we're going to get to questions from the audience soon. I want to ask you kind of about one more issue that I think is on many people's minds today in the U.S. and also I think is quite sharply kind of spoken to by a lot of what's going on at the state level, and that's the loss of trust in the judicial system, and in particular the sense that are judges any different than politicians who are just making decisions in a way that's more dependent on partisan affiliation than on what the law says. And of course, there's an issue at the federal level, but one of the ways in which, in your books, you write about how the states are really quite different. And so Rhode Island is the notable exception here, is that in most states, judges are either always elected, or they're subject, even if they're appointed, they're subjected to retention elections in a way that, of course, it can play out in a partisan or not partisan way, but it's kind of explicitly taking this majoritarian approach, electoral approach towards deciding who is it that's on the bench. And I think, one can pick many different examples, but one I think has seen, especially on state Supreme Court elections, have become increasingly polarized in recent years. And prominent examples from North Carolina or Wisconsin, where judges are almost explicitly running on a promise to make decisions in a way that supports or will defend an existing set of districting or a set of policies in a way that seems to really start to blur these lines. And so, what can we learn from the state experience on this to help us understand this problem of loss of trust in the judiciary as a result of kind of perceived polarization?
Yeah, I mean, that's such a big topic and, really discouraging topic, but I can't challenge your premise. Like it does feel that there's a little bit of loss of trust in courts, loss of trust in government. God knows if this is polarization, internet, whatever, some combination. It's really discouraging. And I think I guess I'll make a couple points about some of the things that have been going on. So let's talk about selection methods and, the elections in Wisconsin, North Carolina, quite a few of the state court elections have been pretty intense politically. I think for one seat on the Wisconsin Supreme Court, there was $50 million spent. That's just so striking. And I think one thing that is worth stepping back a little bit on is remembering that, judges aren't in a position to say, calm down. How can we do that? I mean, the reality in America the last 50 years, maybe even longer, is state and federal judges have been making very big decisions in American society. And I think the intensity of the selection process just reflects that. If judges have a bigger role to play in gerrymandering, marriage, abortion, who can blame the American people for spending a lot of money to get, quote, their judge? What's perilous about this, from my perspective, is that you have to wonder at some point, what does it mean to be a judge? And, Judge Smith and I will take this to our grave, that we don't think when we're selected as judges that it comes with a constituency. We don't think we're representatives of a constituency. We think our job is to honor what the principal has done, which is the people acting through our elected officials to pass laws or have their government execute laws in certain ways. But we don't have a constituency. And I think that's the way it's supposed to be. But you are right that some of these elections, it did look like people were voting for a judge on one side for this set of votes on gerrymandering, abortion, unions, and on the other side for this set of votes, and that's quite troubling. Now, let's give, I happen to know, I think every single justice on the Wisconsin Supreme Court, let's give them the benefit of the doubt. Let's see how they handle these cases. But if it turns out they handled them just the way the electioneering suggested, well, that's on them. At some point, they have to say they're acting a little more like representatives than judges. I will say I'm a big defender of state courts. I wouldn't get too stressed out, though, about saying this is a state court problem, because I very much doubt there's a single one of you in this room that thinks the process for selecting U.S. Supreme Court justices is apolitical. That would quite astonish me. And my point that the intensity of the selection processes have grown is captured by, in 1986, Scalia, true conservative. Everybody knew he was a conservative. Gets confirmed 98-0 in 1986. Justice Ginsburg is, I think, 93. I think she's 96-3. True liberal, progressive. Everyone knew it. But everyone knew they were also smart. Everyone knew they were going to be principled. Everyone knew they didn't have a constituency. They had different approaches to interpretation, but they did not come with constituencies. And so, It's amazing. Justice Ginsburg and Justice Scalia would not be confirmed today unless it was a Democratic president for Justice Ginsburg and there was a Democratic Senate. It wouldn't happen. And in the other direction, you would not get a Scalia without a Republican president and a Republican Senate. And that seems, something about that seems wrong to me. I really admire both of them. I thought they were really good for the court and the country. You can disagree with them, but I think they brought a principled approach to the job and left valuable legacies, even though I probably divided the audience. Some of you are pro Ginsburg and some are pro Scalia, but I liked them both.
Yeah, and I think it's not just about that elections have consequences in terms of who's on the court, right? I think there's a deeper worry that if you take, if people have different but totally stable views of what is a constitutional right at some level, right, it flows into the political process in order to decide, who's making those decisions. I think at some level, even the greater worry is that a given set of judges or justices would interpret the Constitution in a way that's different depending on who the parties are. So, I mean, to pick an obvious example there, in Bush v. Gore, we had 5 conservative appointed justices who voted 5-4 to stop the recount in Florida in a way that ultimately benefited President Bush. And it's hard to know, what would have happened if you had the exact same justices on the Supreme Court, but the positions of, who was ahead at the moment when the decision came down were flipped. But I think, thinking of those 9 people, each reversing their votes if Gore had been ahead instead of Bush had been ahead, that's a very troubling concern.
Well, Bush versus Gore, though, I think illustrates how I'm afraid from some perspectives, the problem's gotten worse. People forget that in Bush versus Gore, on the side of the floor were 2 Republican appointees. Yeah. Justice Stevens and Justice Souter were both Republican appointees. And I think the concern, and I think this is the reason you brought up Wisconsin.
They had become quite a bit liberal by that point, but
the concern is that you can't have a Justice Souter or a Justice Stevens or a Justice White, who was a Democratic appointee, who was a dissenter in Roe.
Yeah,
that ship has sailed, and that doesn't strike me as healthy. And now, I mean, just one thing, just to really emphasize here. There from the beginning of the country's history, there have been 2 approaches to interpretation. One is the kind of more formal, text-based, fixed meaning. That's the Scalia model. The other is more informal, a little bit more about purpose, a little bit less about text, and less worried about it being fixed at a given point. That's more the Ginsburg model. Those models don't inherently favor anybody. We think of those as proxies for conservative liberal precisely because of the abortion debate, because everyone knew an originalist would never think the 14th Amendment had a right to privacy, and everyone knew someone who was more informal would not be too worried about whether substantive due process, should be a doctrine. So they just associated those 2 methods of interpretation with one issue. Once you're outside that issue, I would say all bets are off. And I do think, I feel like I know the court pretty well. That is their focus on different approaches to interpretation. And their real goal, because this is a very hard feature of being a judge, you have to be consistent. You can't say, today we're doing one thing because of a preferred right, and then suddenly use a totally different approach 3 years later because it favors a certain side. That's really quite embarrassing. And I would say shameful for a judge or a justice. And I will say, I do think, I mean, if you take a case from this term, the whole tariff case, if you were to listen to that oral argument, which, you can do, it's really easy to download, you wouldn't, I don't think you'd be thinking they're political judges. I think you'd be saying, wow, those are really good questions. And they're asking them on both sides. They really seem to want to get answers. So even though I realize we're in an era of skepticism, I don't want to finish this topic without saying, I think these people believe in the oaths they took. They believe they have got to find ways to interpret laws that are consistent with that oath, which means they can't be favoring one side or the other. And I think they would all be ashamed if at the end of the day they couldn't say that. So I think they're really trying. I'll just make one other point. If you think you're having a bad day, try being the Chief Justice of the United States Supreme Court or a justice on the court. It is a very difficult job. I think all 9 of them would probably agree with me that their role in American government is probably not their fault, but probably more than it should be. But it's very hard to withdraw. And in our current era, almost impossible, because look what's going on right now. We have a Congress that, I'm not being critical. It's not a value judgment. But for whatever reasons, maybe it's just evenly divided. It's very hard for Congress to do that much these days. And maybe this is, in truth, our fault, not Congress's fault. Like, we're not electing people that are willing to compromise. We're not electing people that believe in getting things done. But guess what happens if you're at the court and Congress is not in doing a lot of things? It means the executive branch fills the vacuum. That's been going on for 12 years, whether President Obama or President Biden or President Trump. Very aggressive executive branch activity. And what does that do? It forces the court to decide whether they can. They can't win. I mean, they cannot win. Even if they wanted to withdraw from all these incredibly fraught issues in American society, what are they going to do? I mean, you have Congress, Article 1 branch. It's the first branch, not doing much. And again, I would blame us, not them. We're the ones electing these people. If Article 1's not doing anything, Article 2 is going to step in and fill the breach and be as aggressive as they can. And that leaves Article 3 trying to figure out, well, can they do this or not? And it's so I realize we're in an age of skepticism, but, maybe a little charity is in order. They're trying, and I do think they're good people. And if you doubt me, listen to the tariffs argument. I think you'll find yourself going, whoa, all 9 of these people are really smart. They're really prepared, and they seem like they're trying to find the right answer without regard to politics one way or another.
So that's a great note. Love to take some audience questions. So we have 2 students who are in Judge Smith's study group, Marissa and Michael. Where are you, Marissa and Michael? Great. So we have a microphone. Marissa can help get you a microphone. Just one thing I want to kind of lay out there in the hopes of kind of steering off some of this. Because Judge Sutton is a sitting judge, right? They're like, for all the reasons we've just been talking about, asking him to weigh in on kind of ongoing legal issues at the Supreme Court or that could come before his court, like he's just not going to be able to answer that.
Well,
and so
I will.
He
but
will
I'm
try.
I'll ask the dean to answer.
Okay. Well, so in order to spare us all my legal interpretations, again, you should ask what you want, but just please be mindful of that. And Nathan, please go ahead with the first question.
Hi, thank you so much for coming. Hopefully this doesn't get too close to anything. It's not really a legal question, more of just a principle question. So a lot of people right now are proposing the idea of term limits for judges. Like I've heard, for example, in the Supreme Court, you're on for 10 years, then you're off. Proponents have said that, you would basically, it would limit court packing and you basically replace justices every few years or so on average. Can you weigh in on that and what your opinion on?
No, I love this question. Happily, I've written about this. I feel so strongly about. Let me explain why the question's so good before I, dip my toes in the answer. The reason the question is so good is it highlights a feature of American government that is unique in American history. World history. There is no country that combines what I'm about to say. The U.S. Constitution is basically impossible to amend. I think it's the second hardest in the world. You need 3/4 of the states to agree to an amendment. That means you can't fix new policy problems that are even remotely complicated with a constitutional amendment. That's the normal recourse. You can't do it. At the U.S. Supreme Court, the justices have life tenure. So what do those 2 things mean? They mean that if the U.S. Supreme Court issues decisions that the people don't care for, they can't correct the decision by amending the Constitution, and they can't replace the justices with new people. They have life tenure. The third feature of this trifecta is that no court in world history has exercised as much judicial review as the U.S. Supreme Court. In other words, when I say judicial review, nullifying democratically enacted laws or pushing back on executive orders by democratically elected governors or presidents. The combination just doesn't exist. So the reason this is such a great question is it's probably in everyone's interest, including the U.S. Supreme Court's interest, to dial back on the life tenure point. Now, there's a lot of ways to do it. I mean, one way to do it would be just as a matter of, whether you want to say just judgment, discretion, justices could just start serving shorter terms. Nothing. It's life tenure. It's not a life sentence. You can leave. 65 is a good year because that's when you get a pension. But after 65, you're working for free. And so one possibility, and I really have a lot of admiration for these justices. So one possibility is that starts to happen. A lot of people assume you need a constitutional amendment to get rid of life tenure. That might be true, but I could see a system where you had an incentive where there was a bump up in your pension if you retired between 65 and 70. In other words, I see a way in which you could urge people to leave a little earlier. But it would require a constitutional amendment otherwise to say, the one that's talked about a lot is 18-year terms. It has the virtue of once it's implemented, which unfortunately would take a long time, of each president for a 4-year term would get 2 picks. So it kind of averages it out. So you avoid this big problem we have of the caprice of when people leave or sadly die. And what a strange, this is why I sometimes really think it's our fault. I'm a little surprised Americans have come to embrace a court with so much power because you'd think you'd prefer the democratic route to winning these disputes, because if you put all your eggs in the court basket, you have this terrible risk that the court might not be to your liking. And that just seems like a really high risk maneuver to me. Now, maybe that just shows I'm a risk averse person, but I currently think your destiny, if we continue with a court with this much power, is you're just going to win half and you're going to lose half. We're an evenly divided country, and they're just going to decide all the mega issues, and half you win, half you lose. In fact, I'll leave you with this thought experiment on this question. I love this question. And don't start answering this because it'll lead to pandemonium, but I just want to leave the grenade and let it go off after I'm at the airport. But here's my thought experiment, which I think you'll find meaningful, is if you're a progressive, find one of your conservative friends. And if you don't have one, time to get one. And if you're a conservative, likewise, find a progressive friend and do this thought experiment where you say, we'll only talk about U.S. Supreme Court decisions since, say, 1960, just to keep it easy. And you find the 5 U.S. Supreme Court decisions that constitutionalize something. In other words, remove democracy from the field. Find the 5 you hate the most as an individual, and then go to your friend from the opposite perspective, get his or her top 5 of decisions for which they're contemptuous. Would you take the trade that you get rid of your 5, but your buddy gets rid of her 5? People find their head explodes when they think about this, but it really illustrates the stakes. Do we want to take off the table the 10 most contentious issues the courts resolved without democracy and go back to democracy or state courts or governors or constitutional amendments? Or do we want to live in a world where 5 of 9 justices are in charge of our fate? And you probably by now know I'd take the trade, but a lot of people won't. And it's kind of funny to me. All right, next question.
Adam, we'll leave on the Adam, and then we can kind of swap it over the side. We can leave for another day the question of whether the others of us in this room that have lifetime appointments should similarly receive some sort of limitation. Adam, go ahead.
Well, no, I'm not going there. I'm a guest.
Thank you so much for joining us today. My question is about the rapid increase in the use of the emergency docket or shadow docket that we've seen this year.
Yeah.
And, by reports, more cases on the emergency docket this year than during the entire Biden administration or the combined Bush and Obama administrations together. And I've heard different perspectives, and I'm curious to get your perspective on whether this is not as big a deal as people are making it out to be, or whether this is a true danger for rule of law and the courts themselves. And I would also be curious, if you don't want to wade as much into the Supreme Court and so forth, about how you choose to handle this issue of emergency cases in the Sixth Circuit, and whether you're seeing sort of similar issues in circuit courts and state courts as you're seeing now at the federal level.
Yeah. These are such great questions. I feel like I should stay for 2 days until we're done. So we've had the emergency docket concept has been around for a long time because we have emergencies. So I talked about death penalties. Whenever there's an execution, there's always emergency filings because obviously an execution's not reversible. So you got to figure out what you're going to do before then. And courts, including the U.S. Supreme Court, have had that. In fact, when I clerked, the year I clerked, that was the main form. We probably once a month had a quote emergency docket stuff, maybe several times a month now that I think about it. The other one that we've had to deal with for a long time are elections because, elections have a date. The rules have to be set before the date, sooner rather than later. So, there's lots of other areas, custody fights. Judges, this is not an unusual thing for judges. So my first thing is to say, this has been around for a while. It's the kind of thing courts just have to do sometimes. And then to try to explain what's different about this. And it is concerning to me. I wouldn't call it crisis, but it is concerning. But there's one feature of this that I think I'm not going to tell you how to think about it. You can be either happy or very, very unhappy with the court on their emergency docket decisions. But I think it's really helpful to appreciate one feature of this as to why they've grown in the last 10 to 12 years, because it has been just the graph like this, really since President Obama. And the thing that's changed, and it's an American polarization thing, is when there's a new president, the state attorney generals, it's a very state power point, the state attorney generals have become very meaningful participants in American government. And what has happened, and I really think it might even have started with the healthcare law, but it did start during President Obama's administration, where you had a whole group of, in his case, the Republican AGs coming to attack the healthcare law. And that kind of let a genie out of the bottle. And everybody has been doing it ever since. And not just with statutes, the healthcare law was a statute, but they've been really doing it with so-called executive branch orders, where new administration comes in and says, here's our immigration policy, here's our policy on transgender, here's our policy on all these provocative topics.
Clean Power Plan, or the
Clean
other
Power
one,
Plan, all these policies that are really important, almost every one of which Congress has authority over. Almost every one of these fights, Congress could pass a law and end the dispute right there. But without Congress making these decisions, it's executive branch versus courts. And so that's thing one. Then the thing two problem, and I'm actually working on a solution to this, I'm very excited to say, is that forum shopping. And don't blame the lawyers, but lawyers are allowed to help their clients. And so what they've done is they've gone to a district that they think might be inclined to agree with their perspective on the claim. And instead of seeking relief just in one state, they initially were seeking what are called nationwide injunctions. The court said no to that. Now they're doing nationwide class actions. And so the trick, and here's my second key point, just to try to put in perspective what's going on before I try to suggest what we do, is that a 4-year term will not outlast most litigation. So if what happens is President Biden puts something in February of 2021, and it's tied up in litigation in Texas, that order, if it's enjoined, he'll never be effective during his whole 4-year term. The courts of appeals, my group, tend not to be very useful here, because what's really going on is it's circuit shopping. They're actually not seeking district court judges they like. They're seeking circuit courts that have favorable perspectives on their issue. So whatever happens, the district court grants the nationwide relief. It's never reversed by the Court of Appeals. What just happened? The U.S. Supreme Court became the Court of Appeals for every district in the country, because if they don't enter the fray, that executive branch priority will never see the light of day in 4 years. So the problem, the rock and hard place the court finds itself in, is if we just say, let's let district courts do what they do and let them do it and not really engage on the emergency docket, then presidents are not going to be allowed to have these initiatives go into effect. And we've now done this for enough administrations to see it's a bipartisan issue. Both sides will be stopped, or both sides will be allowed to move forward with the court suspending the stay through its emergency docket. So the court is really struggling with this. I think all 9 of them, this is a very apolitical point. First of all, it's made the job incredibly difficult. They already have 60 hard cases. Their emergency docket is probably double that right now. Really hard. Like, think of every issue that's big right now. Nationwide citizenship, Humphrey's executor, the unitary executive. Can a president fire people in the agencies? Transgender. I mean, I can't think of a single issue right now that they're not being forced to give an initial take on through this emergency docket. So they are killing themselves. I happen to have a perspective on this. My son is clerking for the chief this year. So I know it's 5 hours of sleep a night. That's all he has time for. I mean, it's ridiculous how hard they're working. So everyone knows this is a problem, and no one's figured out the solution. I mean, my suggestion is that we need to amend our class action rule and just say, listen, you can do a class action in the state, but we're not doing these nationwide classes, because it's really unfortunate. It prohibits other courts of appeals from entering the mix. I mean, and it's actually very bad for the country. Some of these issues, I could have said this about the Biden administration, but I could say it about the Trump administration. Some of their executive branch orders, I won't say which ones, but some of them probably would have failed in conservative and progressive circuits. Wouldn't that have been helpful? Right? To say we don't need the U.S. Supreme Court. This is not that hard an issue. And I think the same would have been true under President Biden. So it's really, we have to figure a way around this. And to me, the right idea is to amend Rule 23 and just don't have nationwide class actions. I think that's it. Because that would still allow people to file 50 cases. And, lawyers like to file cases. I happen to know that firsthand. So it's a great question, and they're really struggling. They've done one other thing is they've taken some issues, this term is a good example, and quickly scheduled them for oral argument. So they did that with the tariffs case. There's thought that they might do it with nationwide citizenship, but they haven't. They did it with the firing of the head of the FTC, the copyright, the Federal Reserve. Those were all cases where instead of just giving a emergency docket ruling, they said, let's quickly schedule this for argument. And so that's not a bad, but you can't do that with every one of them. So they're really, this is a pretty good example of, it's a problem, but this is not a political problem. This is a problem where all 9 justices are like, how do we do this? This is a new problem. It didn't exist before the Obama administration, and it just keeps getting worse. So they're really, really struggling.
Let's get some from this side of the room. Ernie, go ahead. Sorry. Hold on. We got to wait for the back of the room.
Thank you. Thank you for being with us here, Judge. Thanks for sharing your knowledge with us. My question is about your role in national judicial governance. If you could talk more about that, and how much of your time does that take up, and what types of issues do you actually work on in that role?
Well, this is how I got to know Judge Smith, which is really fun because we're both on the Judicial Conference, and it's 27 people, and it's headed by the Chief Justice, and it does set policy for the federal courts, including, basic things like marshals, courtrooms, property, employment rules, you name it. The challenges we faced during our tenure there have been more threats to judges. This is not a great thing. It does not speak well of American society, but there actually have been more threats, verbal threats, actually murders, family members. I mean, it's really quite outrageous. Political figures. This was going on. It's been going on this administration, but it was going on in the earlier one, where political figures critiquing judges and justices often for their rulings. That's not good. So we've had to try to deal with that. We always need money, so we're always looking for benefactors, but sadly it has to be anonymous. No buildings, and but if you're willing to just donate to the federal judiciary, we'll take it. It's really expensive to run a branch, it turns out. I mean, it's not as expensive as the other two branches. We're like a Walmart deal in comparison, but salaries are expensive. Upkeeping a lot of our buildings are old, and of course, security is a very big issue, so we've had to spend more on security. One other one that's quite scary is cybersecurity, and that's nation states trying to hack our systems, and that's a very real feature of the world right now. And so we've had to do a lot of work there, which again requires a lot of money.
Thank you.
Down here, please.
Thank you for being here. You've spoken a lot about the intersection between state and federal courts, particularly as people travel more across the U.S. and move around. I'm curious about technology and how we've seen that more and more play a role in the courts, whether companies, individual actors, civil, criminal, data privacy, AI, algorithms. And I'll try to keep my question as general as possible. But I'm curious where you see the differentiation for cases between state and federal courts, or cases involving technology and the internet that may or may not cross state lines.
Yeah, no, it's a great question. So Congress has authority to regulate, quote, things in interstate commerce, and technology is by definition interstate commerce. So Congress really does have power over almost everything that you could say is technology, whether it's porn issues, threat issues, trademark copyright issues. There's tons of things that are happening, criminal use of technology. I think the Brandeis insight is really useful here. We don't know what to do with some of this stuff. We don't know what to do with cyber stalking. I mean, traditionally, most crimes are defined at the local level and prosecuted at the local level. I think historically, the comparison is there's 17 million criminal cases in the state courts in a given year and 70,000 in the federal courts. So traditionally in America, we've relied on the state legislatures to define and enforce crimes. That probably is still a good idea, even though technically Congress could do this because it does affect interstate commerce. I'm not a econ expert as the dean is, but I'll just say one word that I never quite understood, but it delivered a lot of mileage in answering questions at Williams. Externalities are a pretty good way of thinking about it. And I think there's some things where the externalities are huge and you really need a national government to enter the fray. Environmental law is a great way of thinking about that one. I know that's not your point, but if Ohio pollutes and the winds take it to Pennsylvania and eventually to Rhode Island, it's really funny to think it's only up to Ohio to regulate the environment. So I think you're going to see the internet having that problem. But to me, the internet problems are much more like COVID. We have no idea what we're doing. And Jeff Sutton's solution of shutting the whole thing down as a majority of one. But that's what I would do.
So we have time for, I think, one more question. Take the final question in the back there.
All right. You've shown your love for Ohio, so I'm sure it was very difficult to hop on the plane over here. So thank you very much for coming out to the small state of Rhode Island. But I was curious, as a judge, I'm sure you have a strong sense of justice and perceiving injustice. And we have a long way to go as well. And I was wondering, you've talked about how maybe your moral beliefs might not align with your rulings on certain cases and how that feeling might be. But I'm curious on your thoughts on the system as a whole that might cause that fluctuation. So we are, as you stated, like very different from the rest of the world, and there are democratic nations that seem to be a lot more ahead of us when it comes to progress in achieving a more just world. And this question of federalism might be one that some see as like holds us back in achieving that progress. And you talked about how the Constitution is very difficult and the most difficult in the world to amend. So getting that idea of justice and getting to a just world might be difficult in America. So I'm curious, I guess, like, how do you think that, what justifies like the trade-offs of federalism where
I think I get it. It's this one. I could stay for 2 days and only do this question because I love it so much. And let me just emphasize, this is an unfortunate feature of being a judge. I think it's sometimes an unfortunate feature of being an elected official. You can't always do what you'd like to do. Your position doesn't allow it. And that's why when we talk about justice, equality, things that really matter, it's a problem for the people more than it is a problem for judges, elected officials. And I think it's really important to remember that and think about it throughout your life. Like, okay, I see something wrong. Let's do something about it. One way to think about justice in America is to compare us to Europe. It's a really good comparison because it's not that crazy a comparison in terms of geography and numbers of people. And I'm pretty confident what you would say about Europe is you would say there's some that are doing really well, some countries, and some like you're just ashamed of. That's America. And why is that America? Because you have two shots. The state of Rhode Island can be the most progressive or the most conservative. I mean, they can go all in on figuring this out. And we know the states are very different. So it's a really dynamic process. And to me, it's really exciting. But I couldn't agree with you more that our work is so far from being done. And I'll just illustrate it with two things that I just feel like you're kidding yourself if you think you're going to fix these things nationally because they're so complicated. So one is homelessness. And I mean, it's just a shameful thing that there's not a city in this country where it doesn't exist. No one's figured it out. There is no national solution to this. And it's kind of shameful that we don't all own up that these are our communities and people in our communities, and we haven't figured out a way to deal with this. The second one is criminal law. I mean, Judge Smith and I were talking about this very difficult feature of being a federal judge and all of these criminal cases. And I've got these statistics aren't exactly right, but I'm in the ballpark. When you talk about people that are convicted of crimes in this country, state or federal, roughly a third of them lived below the poverty line before the crime. A third of them have an addiction. A third of them have a mental health issue. Some have all three. It's very rare not to have at least one of those. I mean, how can we not step back and go, whoa, what is going on here? Now, we know as a matter of safety and security, whatever the explanation is, if someone's a threat to others, we've got to do something about it. And that's why we've historically had jails. But there's something about that it should be very disconcerting to anyone that is thoughtful. And solutions to those types of problems are never going to come from one president, one Congress, one court, because they're very difficult problems. If they weren't, we would have figured them out by now. And, a lot of state courts have been in the vanguard on this. A lot of federal courts. Judge Smith is actually the leader of the federal court here in Rhode Island for, you get someone and you decide, it's diversion courts, if I got the right phrase, diversion courts where someone, gets caught and, whatever, they were high and then they come up with a set of rules and requirements to say, we're going to solve this criminal violation a different way. It's going to require you, the person, to do whatever AA, get counseling, these three things. And if you can do them for 2 years, you're not going to jail. Now, that's hard because you got to make sure the person's not going to be a threat to other people. That's a very hard thing for a judge to figure out. But boy, if I ask myself, justice in this country, I don't know. I mean, I'm very unhappy with those statistics. It just seems like we got something wrong here if our jails are filled with people that have those strikes against them, at least one of them, almost every single one of them. And sadly, a lot of people 2 or 3.
Well, on that note, please join me in thanking Judge Jeff Sutton